Picture this. It's late Friday afternoon. You're about to head out for the weekend when your phone rings. It's CISA, the Cybersecurity and Infrastructure Security Agency, calling to tell you they've detected outbound traffic from your company to known threat actors. What do you do? Who do you call? Do you even know where your incident response plan is? If you're breaking into a cold sweat right now, you're not alone. According to recent data, cybersecurity incidents are one of the top concerns, keeping executives and board members up at night, and for good reason. We're talking about lost productivity, theft of intellectual property, ransomware attacks, legal actions, massive financial costs, reputational damage, and, yes, even job security. Today we're diving deep into the legal landscape of cybersecurity. I'm going to walk you through real-world scenarios, show you what can go catastrophically wrong, explain your legal obligations, and most importantly, give you a roadmap for what to do before, during, and after a cyber incident. By the end of this video, you'll understand the legal framework, know the common mistakes companies make, and have a practical checklist for protecting your organization. Let's get into it. Let's start with that scenario I just mentioned. The call. It's Friday at 4:30 p.m. Someone from CISA calls your company and says they've identified suspicious outbound traffic from your network to IP addresses used by known threat actors. This isn't a drill. This is the US government telling you that you've likely been compromised. Now here are the questions you need to answer immediately. First, what steps should your company take once you learn of this call? Second, what's the role of your CISO, your Chief Information Security Officer, in responding? Third, who within the company gets notified? Is it just IT, legal, the CEO, the board? Fourth, does your incident response plan even address how to handle reports from government agencies? And fifth, do you engage outside counsel at this stage? Here's where companies mess up, and I mean catastrophically. Mistake number 1, failure to verify the caller. Yes, scammers impersonate government agencies too, but don't use that as an excuse to ignore the call. Mistake number 2, lack of urgency. Some companies treat this like a routine IT ticket. Wrong. If the government is calling you, it's because they've already detected something serious. Mistake number 3, failure to assume the network is compromised. Don't investigate whether there's a problem. Assume there is a problem and conduct a full forensic examination immediately. Mistake number 4, no procedures in your incident response plan for third-party reports. Your IRP should explicitly cover what to do when external parties, especially the government, report incidents. And mistake number 5, delay. I cannot stress this enough. Delay can be catastrophic. Every hour you wait gives threat actors more time to exfiltrate data, plant backdoors, or spread laterally through your network. The bottom line, when CISA calls, you don't just listen, you act immediately. Let's look at another common scenario, the email incident. An HR employee reports that spam emails are being sent from her company account without authorization. Your internal investigation reveals she clicked on a phishing link. Many companies think, okay, it's just spam. We'll reset her password and move on. Wrong. Here's what you need to do. Notify legal counsel immediately. Bring in an external IT investigator. And here's the critical part. You discover that the employee's email account was synced or copied by the attacker. Now, it gets worse. This HR employee had been collecting COVID vaccination cards from employees in her email. Those are medical records. Under state laws, this could trigger mandatory breach notification requirements. So what are the common mistakes here? Mistake number 1, assuming that because it was just spam, there was no data breach. Wrong. If the account was compromised, you have to assume the attacker accessed everything in that mailbox. Mistake number 2, failing to terminate active sessions immediately. Mistake number 3, not checking for email forwarding rules that the attacker may have set up. Mistake number 4, not searching to see if other employees also clicked on the same phishing link. Mistake number 5, using email as a repository for old sensitive data. Why were COVID vaccination cards from 2 years ago still sitting in someone's inbox? Now let's talk about the IT support scenario. And this one is scary. A threat actor finds a profile on LinkedIn of one of your executives. They see he's speaking at a conference in Arizona. So the threat actor calls your IT help desk, impersonating the executive, and demands immediate access to his account because of an urgent deal. The help desk operator initially refuses, good, but the fake executive gets angry, threatens to fire the operator, and eventually, the operator gives in. Ask MGM Resorts how this worked out for them. This is exactly how threat actors reportedly got in. After initial entry, they gained administrator rights and deployed ransomware that cost the company over $100 million. What are the common mistakes? Over-reliance on it couldn't happen to us. Yes, it can. Social engineering is now the primary method of initial access in cyber attacks. Failure to train staff on social engineering tactics. According to reports, MGM's password reset process only required basic information: name, employee ID, and date of birth, all publicly available or easily obtained information. And here's a shocking statistic: 49% of C-level executives admit they've requested to bypass security measures in the past year. When leadership doesn't follow security protocols, why would anyone else? Alright, enough doom and gloom. Let's talk about what you can do to protect your organization. Think about your data lifecycle in 3 phases. Phase 1, data acquisition. What types of data are you collecting? How are you collecting it? And why? Do you actually need all this data? Because here's a simple rule. If you don't need it, don't collect it. And if you don't have it, it can't be stolen. Phase 2, data maintenance. How is data stored? How is it protected? Who has access? Who actually uses it? This is where encryption, access controls, and monitoring come in. Phase 3, data destruction. How is data deleted and disposed of? At least 32 states now have laws requiring secure disposal of records containing personal information. You can't just throw old hard drives in the dumpster anymore. Now let's talk about the proactive steps you need to take. Number 1, approach cybersecurity as a company-wide risk management issue, not just an IT problem. This needs executive sponsorship and board oversight. Number 2, be proactive through policies and training. You need both. Policies without training are just paper. Training without policies lacks teeth. Number 3, review and assess all third-party agreements. Your vendors are an extension of your network. If they get breached and they have your data, you have a problem. Number 4, understand your data lifecycle. Map out where sensitive data lives, who touches it, and how it flows through your organization. Number 5, test your incident response plan. Don't wait for a real breach. Run tabletop exercises, simulate scenarios, find the gaps before an attacker does. And number 6, make data privacy and security a regular topic at management and board meetings, not just when something goes wrong, proactively, consistently, with metrics and accountability. Let's talk about vendor management specifically. Your vendors can be your biggest vulnerability, so before you sign any contract with a vendor who will have access to personal information, you need to do due diligence. Do they have cyber liability insurance? Do they have security certifications? Do they conduct regular risk assessments and penetration testing? Have they experienced a data breach in the past? And in your contracts, you need specific provisions. They must implement reasonable administrative, technical, and physical safeguards. They must limit access to only those who need it. They must provide prompt written notice upon discovery of unauthorized access. They should be responsible for costs incurred, responding to breaches they cause. They must cooperate with investigations. Don't just trust your vendors. Verify and validate. Now let's talk about the legal framework you're operating under. At the federal level, if you're in healthcare, you're dealing with HIPAA, the Health Insurance Portability and Accountability Act. HIPAA requires that you notify individuals of a breach unless a risk assessment determines there's a low probability that the data was compromised. Here's the key. Under HIPAA, you presume it's a breach unless you can prove otherwise. The burden is on you, and encryption is your safe harbor. If the data's encrypted using HHS-recognized methods and the encryption keys weren't compromised, you may not have to notify anyone. But here's where it gets complicated. State laws. All 50 states, D.C., Puerto Rico, and the U.S. Virgin Islands have enacted data breach notification laws. That's 53 different standards you might have to comply with. The typical breach notification law says, if you maintain personal information and there's a security breach, you must notify any state resident whose unencrypted personal information was accessed by an unauthorized person. So what's personal information? Generally, it's a name plus one other sensitive data element like social security number, driver's license number, financial account numbers, health information, login credentials. What's a security breach? Unauthorized access and acquisition of data that materially compromises security or confidentiality of personal information. Here's the important part. Access alone might not be enough. Many states require evidence of acquisition, that the data was actually taken or copied. Key differences between state laws. Some states cover paper records, not just electronic data. Some states have harm triggers. You only have to notify if there's a significant risk of identity theft or fraud. Some states require notification to the Attorney General's office or other regulatory authorities. Definitions of personal information vary. Some states include biometric data, some include online credentials, some include health insurance information. And timing requirements vary. Some states say, without unreasonable delay. Others specify 30, 45, or 60 days, while still others, like California, basically say, immediately. Two more legal issues you need to know about. First, document destruction laws. At least 32 states require secure disposal of records containing personal information. That means shredding paper documents with cross-cut shredders and properly wiping electronic media. Second, reasonable security requirements. Many states have laws requiring organizations to implement reasonable security. What's reasonable? It depends on the nature of the data, the size of your organization, and industry standards. Massachusetts has one of the most specific laws, requiring written information security programs, encryption of data in transit and on portable devices, and oversight of service providers. And California has said that implementing the Center for Internet Security's critical security controls represents the minimum level of information security for organizations handling personal data. Let's talk about something that might make board members uncomfortable: your personal liability for cybersecurity failures. In 2022, there was a landmark case involving SolarWinds Corporation. If you don't remember, SolarWinds was the victim of a massive supply chain attack, where Russian hackers concealed malicious code in their software updates, ultimately affecting up to 18,000 customers, including major tech companies and US government agencies. Shareholders filed a derivative lawsuit, claiming that directors were repeatedly warned about weak passwords and basic cybersecurity deficiencies, but utterly failed to conduct any reasonable oversight. The court acknowledged that cybersecurity presents a peculiar kind of business risk, and is mission-critical for companies like SolarWinds. The court noted SolarWinds' subpar reporting system between board committees and the full board. Ultimately, the case was dismissed. But not because the board did a great job. It was dismissed because plaintiffs couldn't plead sufficiently particularized facts showing bad faith by directors. But here's the warning. The court made it clear that boards must actively oversee cybersecurity risks. As SEC Commissioner Luis Aguilar stated, boards that choose to ignore or minimize the importance of cybersecurity responsibility do so at their own peril. So what should boards be doing? First, evaluate your most critical assets in relation to cyber risk. What data, if compromised, would be catastrophic? Second, make cybersecurity a regular agenda item at board meetings. Document these discussions in your minutes. Third, ensure employees receive regular security training. Fourth, establish an enterprise-wide cyber risk management framework. Fifth, create a cyber risk management team that reports directly to the board. Sixth, participate in breach simulation exercises at least annually. Questions every board should be asking. Does the board understand the company's exposure to cyber attacks, including financial, legal, and reputational impacts? Has the board practiced a cyber breach simulation with management in the last year? What critical assets and partners are most vulnerable? How does management evaluate incidents and determine which to escalate to the board? Now let's talk about the SEC enforcement action against SolarWinds, because this one is different. In October 2023, the SEC filed a complaint not just against SolarWinds, but against its CISO personally, the first time the SEC has charged a CISO with fraud. The allegations: that SolarWinds made materially misleading statements about its cybersecurity practices. For example, claiming they followed the NIST framework when they had no program in place for the majority of the controls. Not maintaining a secure development lifecycle despite claiming strong cybersecurity practices. Failing to enforce password policies. Passwords weren't individually encrypted or properly hashed. having extensive access control problems despite public claims of strong security. Here's what's terrifying for CISOs. The SEC sought to prohibit the CISO from serving as an officer or director at any public company. In July 2024, a federal court dismissed most of the claims, finding that many statements were non-actionable puffery and that the SEC's authority doesn't extend to regulating corporate cybersecurity controls generally. But, and this is important, the court allowed some claims to proceed related to specific misrepresentations in SolarWinds' public-facing security statement about access controls and password protections. The takeaway? If you make specific, detailed claims about your cybersecurity controls publicly, you better be able to back them up. General statements like, "We take security seriously," are probably okay. Specific claims like, "We follow NIST" or "We use strong password controls" better be true. Let's bring this home with a quick walkthrough of what a ransomware attack actually looks like in real time, because this is where all the legal and practical issues collide. Monday morning, IT discovers a ransomware attack. Employees are locked out. You find ransom notes on workstations demanding payment in Bitcoin. Immediate actions. Do not use your regular IT support firm for the forensic investigation. Why? Because if litigation happens, you want the investigation protected by attorney-client privilege and work product doctrine. Have legal counsel engage the forensic investigator. Contact your cyber insurance carrier immediately. They often have preferred vendors and can help manage costs. Activate your incident response team. This includes IT, legal, compliance, communications, HR, and affected business units. Day 2. The threat actors send sample files proving they have your data. Some files contain customer information. Some contain employee PII. Legal question. Is this a breach yet? Maybe not. If you can't confirm the data was actually exfiltrated or accessed, many state laws don't require notification yet. Day 3. Your backups are corrupted. The threat actors got those too. Now you're facing the ransom payment decision. OFAC compliance issue. Before paying any ransom, you must verify the payment isn't going to individuals or entities on OFAC's specially designated nationals list. U.S. persons are prohibited from transacting with sanctioned entities, even if you didn't know. The penalties are strict liability. Day 4. Threat actors start calling employees, launching DDoS attacks on your website, and threatening to release data. Employees are panicking, customers are calling. This is where crisis communications becomes critical. You need prepared statements, talking points for employees, and a media strategy. Day 5. The threat actors post 15 sample files on the dark web, including confidential litigation documents subject to protective orders, employee PII, and documents related to a pending acquisition. Now you definitely have notification obligations. But to whom? Employees whose PII was exposed, customers whose data was compromised. The other parties to the litigation under the protective order, potentially state attorneys general, depending on the number of residents affected. The SEC, if you're a public company and the breach is material. Under the new SEC rules effective December 2023, you have 4 business days to file an 8K after determining a cybersecurity incident is material. Critical mistakes companies make in ransomware scenarios. Mistake number 1. Treating the IT environment like normal operations instead of a crime scene. Preserve evidence. Mistake number 2. Having an employee who started last month handle media communications. This requires experienced professionals. Mistake number 3. Not knowing who makes the decision about whether to pay. This should be decided before an attack. Mistake number 4. Not testing backup recovery. Companies that discover during an attack that their backups don't work are in serious trouble. Mistake number 5. Data hoarding. Companies that keep unnecessary data for years are creating unnecessary risk. If you don't need it, delete it. Let me give you one more quick scenario. Business email compromise. Your construction contractor calls asking about a $250,000 payment that was supposedly due. You have records showing you wired the money, but they never received it. What happened? An attacker compromised an employee's email through phishing, set up forwarding rules to hide legitimate emails, and sent a fake email with new payment instructions. Your employee called the number on the email, which went to the attacker, who verified the new bank account. The $250,000 is gone. Is this a data breach? It depends on what else was in that employee's email account, if it contained tax information, vendor contracts, or customer data. Yes, you may have notification obligations. Who's responsible for the lost money? That depends on your insurance coverage, your vendor contracts, and potentially your wire transfer agreements with your bank. Alright, let's wrap this up with key takeaways. Takeaway number 1. Preparation is everything. Have an incident response plan. Have an incident response team. Test it with tabletop exercises. The time to figure out who does what is not during an active attack. Takeaway number 2. Board oversight matters. This isn't just an IT issue, it's a governance issue, a legal issue, and a business continuity issue. Boards need regular briefings and documentation of oversight. Takeaway number 3. Vendor management is critical. Your vendors are extensions of your network. Review contracts, require security provisions, and have a process for vendor-caused breaches. Takeaway number 4. Know your legal obligations. Federal laws like CompTIA, state breach notification laws, SEC disclosure requirements, OFAC sanctions, these aren't suggestions. Violations can result in massive fines and personal liability. Takeaway number 5. Slow down. One of the most common causes of breaches is rushing, bypassing security procedures because of time pressure, clicking on emails without thinking, or making wire transfers without verification. Teach employees that security is more important than speed. And finally, takeaway number 6. Stop hoarding data. If you don't need it, don't keep it. The best way to protect data you don't have is to not have it in the first place. Look, cybersecurity law is complex and constantly evolving. What I've covered today is just the foundation, but if you take away nothing else, remember this: the time to prepare for a cyber incident is before it happens, not during. Do you have an incident response plan? Do you have a team trained to execute it? Have you done a tabletop exercise? If you answered no to any of these questions, that's your homework. If you found this helpful, hit that like button, subscribe for more legal and compliance content, and drop a comment with your biggest cybersecurity concern or question. And if you're an organization that needs help with incident response planning, vendor agreements, or navigating a breach, reach out to experienced cybersecurity counsel. Don't wait until you're in crisis mode. Thanks for watching, and stay secure out there. If you found this helpful, hit that like button, subscribe for more legal and compliance content, and drop a comment with your biggest cybersecurity concern or question. And if you're an organization that needs help with incident response planning, vendor agreements, or navigating a breach, reach out to experienced cybersecurity counsel. Don't wait until you're in crisis mode. Thanks for watching, and stay secure out there.